What's going on, my brother? Hey, you been kicking some ass. Oh man, I've been watching your videos. I'm like, oh my god.
Greetings. I'm setting my phone up so we can go live on Facebook. We are live on Facebook right now, but it's just
Okay.
you and I in the Zoom. I did invite Melvin Washington, but I did not get a hold of him. I left him a link so he might pop in with us. But so let's get started. First of all, you're on key when it comes to the research I've been watching you do in regards to trust law and contract and everything, and I hope people will start catching on that we are the ultimate contractor. And the ultimate contractor is one that places the words in the documents that qualify the contract. That qualification must be done in trust. All contracts operate in a trust. A simple contract is, in fact, a simple trust between two men, and that does not require a trustee. It is just a gift exchange between each other according to the terms of their private contract. And so when we think about this, we think about the imports and exports that are exchanged in today's commercial realm according to those contracts under their commercial trust. And what it comes down to is a term that many people are not familiar with, and that is an entrepot. And I'm sure you heard me speak about this in the past. I come across this a few years back. And what it is an entrepot is a central point for a entity for imports and exports. They are the control center for imports and exports for their organization, their association, their private foundation, whatever they classify themselves at. In this situation that we're in the modern world, the nation's capitals are those entrepots for the various different countries under that federal jurisdiction. So we have 50 states in the Union that ceded their jurisdiction to the United States as the central post for imports and exports, known as the entrepot, the port of entry. Entrepot, port of entry. And so what we've got is, and I'll go to, let me pull it up here. Get my screen set up. And this is, and notice it's in relation to geography. Like I said, it's the central point from where things come and go in accordance to the language of that central point's contracts with its customers outside of its actual borders for its exports and imports. And so it says, and notice it says in the top here for the ledge in the International World Wide Web, it's geography.name entrepot. So your center of import and export is by a name control, and then your imports and exports have that origin name with an enumeration for whatever contract it's dealing with. So if it's got several contracts, all of those contracts are going to have different numbers. That's how the system works. Most systems. You can have your own private filing system that doesn't use either. You can use your own special code. But generally things start out with a name first so that they can title it. An entrepot, from the Latin emporium, is a settlement founded specifically for a commercial activity or a market or mart located within or on the periphery. This is what we're talking about with in law and at law. Okay? Your law is within your periphery. What others can see from their periphery in accordance to your periphery is their at-law perspective. Your in-law and contract makes the law, so it's in your contract. Again, you're the contractor. You're the originator of the contract. So you have to make sure it's your contract. Otherwise, you're at law. You're looking externally at somebody else's internal contract. That's why you have to make sure any contract, the proper party, the party of interest must be named. If it's not, it's an invalid case. Period. This is the problem. Everybody else is looking at you from a periphery in their at-law position and giving you a name, associating it with their record, and calling that you. The name and number identify a record. It does not identify yourself. So, of an administrative political center. Administrative or political center. So you can administrate your own private affairs without a polity. I do not have any political views. I do not register. I never registered to vote. I do not vote. I don't care about politics. I care about truth. And politics is a bipartisan view, an opinion on what is true. And that's why no court can accept any facts or truth in law. The origins of the Entrepot are traced to a commercial behavior of ancient societies. This is Babel. Traders entering foreign territory. Upon entering a foreign territory, you're supposed to make a declaration of peace, or else they would recognize you by the flag you carry under the law of nations and the laws of war, the law of flags. Otherwise, you carry a word of peace. A man's word is his bond. Therefore, going into a foreign territory, you create your own bond through your actions and the oral speech that you give. We're exposed to numerous natural and cultural hazards. This is why they have to protect people outside of their territory, because they want people to come visit them. Otherwise, they wouldn't be able to conduct their foreign affairs. They have to be able to provide some kind of protection beyond their borders, and that protection rides in the contract. It's known as insurance. That's it. And that is the comity that they have with the outside partner to post at one point, get it to the second point, and post it again. Point of origin, transit to final destination. That's as simple as it gets. And everything in between, because of those two parties, they're supposed to protect. This is the inland marine stuff, the inland characterization of admiralty maritime jurisdiction in regards to nations that have internal countries that don't have access to the waterways for that foreign trading. So they have to give passage protection over the lands for internal countries that don't have their own waterways, because that's the main trading routes for foreign countries. That's where everybody has their entrepots, is on the borders of waterways. They're called shipping lanes. Before, they're called railroads or transportation roads, all of which are postal roads and routes. That's who protects all of those transits between contractors, because they are the international contract authority. In addition to facing harsh travel conditions, they might be attacked by brigands and find themselves in places where they did not know the local languages or customs, and were subject to territory-specific laws. This is why it's so important to know the international laws rather than your nation's laws, because if you're stuck on your nation's laws and wanting to claim more nationality or anything this, rather than scriptural writings based on a nationality, then you're claiming a nationality as saying that language rather than the spiritual language that created that nation. This is the 12 tribes. When they speak about going forth and building nations, it's a spiritual nation, not a commercial nation based on a patronage, a earthly father patronage. We're not supposed to honor any earthly father, for there's one Father which art in heaven. That is our entrepot. That is our center of imports and exports, and it is done by the biblical scripture, the word that bonds us to our scriptures. The scriptures should be our holy writs. The scriptures should be what we use for our contracts, under which they would find no protection. See, when you're following under that nation's thing, then you're subject to it, and they are not required to protect you because you have involved yourself in the protection element, and you're supposed to protect. This is the object of being surety in court. When you walk in there and use that name and address rather than the number, you're stepping into a surety position, accepting the language used by accepting the name and number as it's constructed for its intent. Foreign merchants required neutral sites of exchange. This is the scriptural language. I know, and this is why I want to talk to people that are involved in the Muslim languages and stuff. The Torah, the Buddha, the Hinduism and stuff. I want to learn those other languages because I know there's similar language to Jeremiah 1:5 in the King James Version. It says that we are all prophets unto the nations, that we were sanctified and ordained by him. That means no commercial nation can use their commercial ordinances to sanction the word of God. And that correlates with honor all prophets in the Quran. It's the same thing. It's just worded differently. Again, telling us that we get our point of Entrepot, our center point of imports and exports of our language from our scripture. And before we get to any commercial element, it has to be discussed in some kind of language. So that's the language we should be using to construct these contracts. Is that the trust language? Because again, all commerce operates under a trust. And if you saw the video yesterday, I showed you where their postal trust is, and that is relative to the ecclesiastical trust. So I'm going to drop this link. I'll do it both in the Zoom, or actually what I'll do is I'll do it on the Facebook, and then the guys here, I'm hoping Melvin will walk in with us. I invited Melvin Washington as well because I know this would pique his interest and he might have some say in it that would help as well. So I'm hoping he'll walk in. But anyway, I'll post all the links on my Facebook video when I'm done. But right now I want to get on to the next one, which is not so much a link here, but a reading or some reading from a couple books. Now, what I do when I get materialistic readings and stuff, I will use them and make notes. But you will notice that most of them are not like a lawyer's books where they've got all kinds of notes. I like to read my material a couple times and find an interesting piece or two that piques my interest, that correlates what my research is. This book, corporations and business, corporations, business, and other associations. These are like private foundations. And this goes to the very fact of incorporation under the laws of the United States or any nation that you're in. And it's called constructive fraud. This is according to their business model, Business Corporation Act. And under section 2.03, it says incorporation, and under the official comments, it says conclusiveness of Secretary of State's action on question of individual liability for corporate actions. And what it says is under section 2.03b, the filing of the articles of incorporation as evidenced by return of the stamped copy of the articles with the fee receipt is conclusive proof that all conditions precedent to incorporation have been met except in proceedings brought by the state. If you guys don't recognize that, it says return the stamped copy. Under an incorporated setup, however, those party to the incorporated status are not required to put a documentation stamp on their documents. That's why it's, however, it's not brought by the state. So an individual bringing it has to have what they call a capital transfer stamp put on the document for the capital transfer of the incorporating status. It has to show that whoever is incorporating under the laws of the United States is actually bringing assets to the table that they can then convert to capital for collateralization of credit. Okay? Without that, you are not incorporated. You are not organized. And without being organized, you cannot be organized and have a board of directors, an accountant, all those other things, and it takes a board of directors to hire an attorney to make a presentment in a court. You are neither suable, nor can you be sued in those courts until you incorporate under the laws of the United States or whatever nation. Until you do that, you are still presumed a private foundation according to that nation's tax laws. It is only upon reporting to that nation's Internal Revenue Service that you present that you are organized and are now ready to incorporate under those nations' laws. Otherwise, you remain as your own Entrepot. You are not subject to their language yet because you're not incorporated under their language. It goes on to say in section 2.04, liability for pre-incorporation transactions. All persons purporting to act as on or on behalf of a corporation, knowing there was no incorporation under this act, are jointly and severally liable for all liabilities created while acting, or while so acting. This goes to that name and address. Using that name and address, that address has a municipality, a state, and a federal element. And you are claiming to be a resident in that trust, and the only persons allowed to reside in that zone are federal, state, or municipal officials or agents. And if you have not taken an oath of office or incorporated under those laws, then you are making a false statement by giving a name and address, placing a presumptive liability on the record as surety by use of that name and address. And so again, we go to 19 CFR 194.3, data elements and proper entry into the record. The importer of the record is liable, and the buyer, the seller, and the ship to party can all use a number in lieu of the name and address. And again, that number will trace back to a record with a name. The name and number identify the record, not the living soul. Okay? So let's get on to the next one. The next one, we're going to talk about the Treaty of Berne, because this is where it's all incorporated in through your intellectual property rights and the ability to speak your mind. Treaty of Berne protects intellectual...
Before you go forward, could you state that code again?
19 CFR 149.3. And that one code will explain a lot to you. It talks about the country of origin, final destination, harmonized tariffs schedule of the United States, all kinds of things. And it's important to realize the two things that I mentioned in there is the importer of the record is liable, and the buyer, seller, and ship to party are all allowed to use a number in lieu of the name and address. And this is what I'm going to do in any kind of documentation from now on. If they ask for a name and address, I'm sorry, I can't give you that. If you want a name and address, I give you a number to search up that file with the name and address connected to it. And you will see that the address is that of a beneficiary, and the address of the liable party is the Social Security Administration, who is holder of the record. A holder of the record is liable. I only use the record, and in using that record, I use the number to refer to that record, called the law of referral, and that is all I need to do. I'm the beneficiary. I'm not required to do anything. All I have to do is let you know where things are at so you can administrate the assets properly. Because if you think you've got assets for me, you're wrong. I've not been incorporated. You can't have assets for me. There's no such thing instituted into the record yet. So, the Treaty of Berne, formally, the treaty concerning the formation of a general post union. General post. See, people think about the general delivery. Instead of getting an address, they go down to the post office and they sign up for general delivery. And I keep telling them, no, it's wrong. You're still entering delivery into the transportation system. It's general post. You're the one making a post. You are posting your articles. And every time they add something to a document, it's called a post. They are posting something to the record. It's all postal. Signed on 9th of October, 1874. Established the General Postal Union, which is today known as the Universal Postal Union. Named for the Swiss city of Bern, where it was signed. The central place where it was signed. Where it took place. It's the contract. It is the entrepot for all imports and exports around the world. The treaty was the result of an international conference convened by the Swiss government on 15th of September 1874. It was attended by representatives of 22 nations. Plans for the conference had been drawn up by Heinrich von Stephen, Postmaster General of the German Reich Post, who demanded from the neutral, it's a neutral body. That's why we go to the Treaty of Berne. It's neutral. The law of nations is set up in contracts for those controversies where the neutrality no longer stands. They come into conflict. This is the other side. Both of those are indentured by the Constitution of the Universal Postal Union. Switzerland, the organization of an international postal congress. This is where the Congress of the United States is subject to. That constitution that they operate under and delegate all the authorities to the United States and the states has to get their authority from the International Postal Congress. The purpose of the treaty was to unify disparate postal services and regulations. Notice the black and white. Everything's black and white in this forum. Everything is black and white. And the regulations so the international mail could be exchanged freely. Freely, folks. That's at no cost. They're telling you right there, that's the establishment. Regulations so international mail could be exchanged freely. If you're operating in that U.S. postage stamp, going down there and buying stamps, you're not operating in international mail and using freedom of transit. You are subjecting yourself to the postal contract, not the postal trust. The signatories of the treaty were German Empire. Okay? Established by the treaty was renamed the Universal Postal Union. Okay? Again, this is a link I'll drop and let you read the rest of it. It's going to show you all these different treaties. These are like those 560 some sub-treaties that I was telling you about, folks, that reside under the Uniform Customs Code. Her Majesty's the construct is the Treaty of Berne, the Law of Nations. Both sister documents, one neutral, one for conflicts. They are both indentured under the Constitution of the Universal Postal Union. Under that, you then have the other 560 treaties indentured through the contract known as Her Majesty's Uniform Customs Code, which is the tax laws for all of those treaties under the Law of Nations. Okay? So let's go to the next one. The establishment of the German Post. Fern und Taxis. Or is it taxis? You know, people get into taxis all the time so they can transit from point A to point B, and they pay the tax guy because he's providing a transit service. The princely house of Thurn and Taxis is a family of German nobility, the empire, that is part of the Briefadel. It was a key player in the postal services in Europe in the 16th century until the end of the Holy Roman Empire. All roads lead to Rome, not any longer. They lead to Germany. Look at the general population of the United States of America and most all of your countries. It is 40% German. 40% German. Think about this, people. Another link I'll leave you. Let's get on to the Treaty of Berne. Before we get into that one, it's a multilateral agreement. It's a multilateral agreement already. And these are the 10 protocols that you'll see in the 10th protocol. It's different developments and amendments that were made through these different amendments from various different country members. And each one of them is allowed to put their amendments on them with the declaration to the effect that the accession shall not apply to Articles 1 through 21 of the Convention or the Protocol. So you can make your own amendments. But what you got to do, again, you got to adopt for ratification. That's all you got to do. You don't have to ratify. You just have to adopt it and agree that, okay, yeah, I agree with the terms of peace. If I ever decide to incorporate, I can follow up with those 1 through 21s. But for now, I'll stick with Article 1, where it says freedom of transit is guaranteed throughout the entire territory of the Union. And I guarantee you, if I end up with land or property, that if a postal service worker needs to cross that land and pass through that land, I will allow him to do so peacefully. I am neutral. Okay? That's all we're doing. That's all we're doing. Now, in regards to the patent intellectual property rights, again, you see all these different countries and everything. And it says, Berne Convention 4. The protection of literary and artistic works. That's the intent of the Treaty of Berne. The Law of Nations, the intent in there is making certain declarations while you are in war, which is while you are in contract. While you're in contract with a nation, as another nation, you use stamps for the collateral transfers of capital assets. If you're subject to the nation, then you're just passing notes back and forth, promising this and promising that. Internal documentation is not required to have stamps, and therefore it's only dependent upon the agreement of the internal parties and has nothing to do with the Treaty of Berne. You are subject to their war, called war rants, written on paper. That's their literary work. Starts out, Article 1, establishment of a union. Union. In the preamble of the Constitution of the United States starts out with to form a more perfect union. And it is stated in the Constitution of the Universal Postal Union. And here, the establishment of that union, that freedom of transit is guaranteed throughout the entire territory of the Union. And then when you think about Title 18 of the U.S. Code, Section 7, Special Maritime and Territorial Jurisdiction. This is the territory of the Union. All freedom of transit is guaranteed throughout the entire territory of the Union. That's the Special Maritime Territorial Union. Protected works, literary and artistic works. Possible requirement of fixation. Now this is the intellectual property being changed to physical, tangible property by fixating it in paper. It's possible, but not required. Man's bond is his word. Man's word is his bond. If he can speak his word, there's no reason for him to need to write it down. If they need a record of it, they can write it down. That's why they have notaries and certifications. and it goes to derivative works, official text. Official text, that's that context that I was talking about in the video yesterday. Their languages are all parlances in the context which they speak, whether it's political context, legal context, spiritual context, commercial context, medical context, mathematical context, whatever. They're all different languages. So when we drop out of the spiritual language and go to one of those other languages, we're already losing. We're already in a losing position. Collections, obligation to protect. I have an obligation as my brother's keeper, not only to protect him in his physical form, but to protect his thoughts. And that is the beneficiaries of the protection is my brother, as I am his keeper under the word. Not any actions of mine or anybody else's, but the word of his will. Thy kingdom come, thy will be done. So it's not my will either. It's not my word and it's not my will. It's his will, his word. That's all I'm doing. Works of applied art and industrial designs. These are industrial designs. All of their laws, everything written is of an industrial design. Even Tom Sawyer is written in an industrial design, but it's protected through a generation-skipping trust concept that says the beneficiaries are the protected ones. The beneficiaries of the writing of Samuel Clemens are protected through his artistical writings. So that when Canada got his artistical writings that were published in England and they reached the markets of America before his publishings from England reached America directly, the import and export capabilities of Canada allowed them to violate his creative works and profit off of them in the American markets before he was able to make profits off of them in the American market, because Canada, through their imports and exports, got them first and were able to then import them into the American markets before the import-export contract from England actually activated for the American import-export direct. So they, even though he was able to import directly to United States and Canada separately, the contract for the import-export to Canada worked quicker than it did for America, and that allowed Canadians to make a profit off the American market before Samuel Clemens himself. They didn't have any right to do that. They weren't part of that contract. Their contract said they could distribute it in theirs, and then other people that were able to market it within Canada use Canada's trade laws, import-export laws, to then independently sell it for their own purposes to the American markets. That's the violation. You can't do that without Samuel Clemens' authority directly. He is the controller of the contracts. So if you want to then use a intermediate contract, you still have to go to that superior contract. We have to learn to quit using these inferior false contracts and trusts. The next one is possible limitations of protection of certain works. This is the possible requirement of fixation. They cannot require you to write what you think down. They cannot require you to write your thoughts down. Certain speeches, when you go out in the public to protest the government, you cannot use hate speech, but they have to allow your certain speeches. Certain uses of lectures and addresses, you can go out on a public podium and read something that somebody else wrote in the public domain, as long as you're not doing it as for a profit. Rights to make collections of such works. You have the right to construct your own library, and this is why I adopted the Hatha Trust, because it includes the Library of Congress and the libraries of many universities throughout the world. And so I adopted the Hatha Trust so I could make a collection of works as a consortium library. Consortium library. You consort with your cohorts. You consort with your people that you communicate with and educate each other with. Learn from and learn with. Criteria of eligibility for protection. Nationality of author. That's why the criteria starts for the eligibility of protection is the nationality of author. The nationality is never mentioned except for the parties, the nations subject to the contract parts. As a private foundation, not organized and not able to contract under a nationality, I don't have a nationality, but I have the right. The same intellectual property rights of thought without nationality. Place of publication of work. This is important because, like I said, the postal roads and routes. If you're placing a publication and you're doing it through the nationality of a publication, a written publication, then you might be doing it in the wrong place. This is why I established a World Wide Web international electronic publishing site. It reaches the national forum first and foremost before it hits any paper. And the national forum already recognizes me as a private foundation without a nationality. Simply by the word, because they allowed me to keep posting those words. They find no violations, otherwise they would remove my site. Criteria of eligibility, Again, a lot of this stuff you can read and find out. And eventually I'll go through this word for word and do it in depth. I will do an in-depth on this as well as like I'm doing an in-depth on the Libra code. As soon as I get my Zoom set up so I can do the long Zooms, I will be doing classes on the Libra code. Term of protection for works and joint authorship. The term, like I said before, the term is the length of time. And this is what I was talking about with Tom Sawyer and Samuel Clemens. The term of time, when Canadians were able to receive it, the term of a protection of a work started when he created it. And they can't violate that on the other end by saying, well, we've already got it, we're going to disseminate it by our own choice. Then you have a right of translation. That's why when you go into these courts, you better have a translator. You better have a translator. We got 10 minutes left, folks. I'm going to go ahead and wrap this up here real quick. Certain free uses of work, quotations, illustrations for teaching, indication of source and author. This is what I use. I illustrate through my opinion of teaching the indication of source and author of other material that I get in the public domain, and I give you the sources and authors. I show you all the links of where I'm getting this stuff. So there is no charge. It's free use, called fair use. And for that, because I'm using it fairly without charge to me, I can't charge for it. The only thing I can charge for is my expertise or something in private counsel. In the public domain, I can't charge for it. But even in my private counsel, I don't charge. I give freely. Just like this, I give freely. If you want to donate, I appreciate the sharing of the love, but I've got to do it. It's my duty to teach. And I have to do so freely. Then it goes on, it talks about further possible free uses, certain rights in dramatic and musical works, broadcasting and related rights. We have the right to import through our observations, make a determination, and then export it through those observations. This is where the translation comes in for other people. We are in law according to our imports and exports, and we are just putting out our opinions. When other people take it as an aggression or a conflict, that's on them. That's that at-law thing. It doesn't matter what your opinion of me is. I don't care. Unless you can prove what I'm saying is in fact a lie or libel being written down on paper, then you have no say in it. None. Droit de suite in works of art and manuscripts. Right to an interest in resales. This is the droit. You spoke about that before, brother. Droit. This is the droit de suite. This is why you file suits, is because somebody else has an interest in the resales. This is what Samuel Clemens did when he went to Congress. He didn't go to the House. He didn't go to the Senate. He didn't go to a lawyer. He went to Congress and issued his claim. And he let them know he had an interest on the resales in America from the Canadians that were selling it to Americans. Infringing copies, possibility of control to circulation. This is that name control. Samuel Clemens is the first person. Mark Twain is the second person in the writing. And then Tom Sawyer is the third person. He's complete fiction. Mark Twain can only be verified through Samuel Clemens. Samuel Clemens can only be verified by himself, letting other people know that you may call me Samuel. That's it. So I'm going to drop off here. We'll continue on another one. If you want to go ahead and hook up here right after I get done, we could do another one, or give yourself some time to go over some of this material, brother, and then come back and do again another one later today or tomorrow or something if you want. But I'd like to go further into this for you and other people to show you this is our starting point. We have to start in peace. We have to start with truth, and we have to be able to learn how to construct it in a way that others can see it and know that we are already in agreement with their concept of peace.
I want to go. I'm ready for some more. It touched everything that I'm doing anyway.
Right.
So it's already in correlation. It's just a confirmation. Like when I hear everything you say, just confirm everything that we were doing.
Yeah, and I've spoken on the Constitution of the Universal Postal Union before in regards to their Articles 26 through 32, I believe it was, where it talks about acceptance and entry into force of acts for countries of the Union. This is where you can indenture yourself through the ratification, accession, and possibility of excluding certain provisions, withdrawal of exclusions, entry into force of Articles 1 through 21. And then there it is, 22 through 38. Those are the articles in the Constitution of the Universal Postal Union, the protocols for entry into the Union, to be at law. Otherwise, you're still in law if you don't enter into their at-law jurisdiction. This here is at-law jurisdiction. Articles 22 through 38 are at-law jurisdictions. Articles 1 through 21 are the explanations of the at-law jurisdiction. And Article 1 is the one that explains freedom of transit is guaranteed throughout the entire territory of the Union. So you can accept it in entirety with exclusion of everything but Article 1, available for ratification and entry into the Union based upon becoming fully organized. Does that make sense? You're not fully organized, so you don't have to comply with that. You stay in your in-law position and let them know every step of the way. Well, I can't accede to that because my scripture says I'm not supposed to contract. However, we can make a trade agreement where you donate something to me freely and I donate something to you freely, and privately we can agree on the equal consideration of those benefits to each other. Once that's agreed, there can be no further detriment because the agreement is done and over with. The exchange is made and there's no future liabilities. It's done. It's over with. Does that make sense? So anyway, that's the one book. So yeah, I agree we should come back.
Yeah, I want to come back. I mean, this is getting really juicy for me. Like I said, I challenge everybody. Like, this is some of the best work I've ever seen, period, on the internet. Like, the stuff that you bring, and it just correlates with everything me and Marvin been working, and it just correlates with everything that I'm trying to do. And like I did a video today that, you know, in these mortgage agreements, one of the aspects that I started doing years ago was filing criminal charges for dereliction of duty, swindling, confidence games, those kind of elements, because they were stealing your benefits.
Yeah, and that you're exactly right. It's a confidence game. I spoke about that in one of my videos a couple days ago too. Is confidence. In that is the word "fide," and that's where we get fidelity, as in fidelity bonds. And the only one you need a fidelity bond with is a postal service. Now, fidelity bond is by recognition of the Treaty of Berne that the armistice is already in place. It's already there. We agree to act in peace. So let's act in peace and not enter into the war of warrants, war rants, controversies, conflicts. We're not here for that.
Man, this makes so much sense.
And you'll notice a lot of the states in their codes and stuff, and even the U.S. code, you'll see the word adoption. Adopted for amendment or whatever. This is what they do. They adopt municipal codes or statutes adopted. They adopt the statutes, and then they have a municipal publishing company that rewrites it according to their interpretation. It's merely an adoption, and they're enforcing it as if though it's an actual statute. No, you have to go to the statute. The municipalities can't just adopt a statute and say, okay, now we can enforce it. The statute has to be enforced by the statute holder, and that's the state. The state holds a contract with the federal government under 48 CFR 52.212-5, contract terms, conditions required to implement statutes or executive orders - commercial goods or commercial services.
I've got one thing to ask you, and this is what a theory I have. Gross negligence. Like, they put us in a position to be an employee, never trained us, right?
Yes, that is gross negligence. That's what I pointed out with Social Security. When you apply for Social Security, they automatically dual eligibility enrollment through a Medicare qualified government employee. But you don't get Medicare, you get Medicaid. You're not qualified for Medicare until you reach the point where you're competent to fulfill one of those offices or act as an official or agent of the federal Our Zoom ended, so my live is still continuing on Facebook. So the federal, state, or municipal officials or agents. If you do not qualify for that, then you do not qualify to be doing anything but adopting whatever they say so you can correct it. That's all you got to do. So in the meantime, I'm going to get with Brother King L. Bay and figure out whether we're going to come right back or do a Zoom later. So pay attention. We might pop right back up and do some more. In the meantime, remember, if it weren't for you guys, I wouldn't be doing this. God bless. Have a great day, and we'll see you soon.